So the United States, like many other countries in the modern world, have various regional and bilateral agreements that are known under this general rubric of a free trade agreement, an FTA. So examples of this would be the North American Free Trade Agreement, NAFTA, or the free trade agreement with the Republic of Korea, and with a host of other countries. Now, a partial list of those countries can be seen in this box. And this is increasingly an important way in which the United States has liberalized trade outside of the WTO system, where these are agreements where the members get a better deal than other WTO members. So there are a set of structures and chapters in the agreement that deal with certain economic interactions, which are really very much a part of the U.S. approach to this. And this, broadly speaking, is a type of deep integration, as it's known, where the United States is unusual, and certainly quite different than some of the other countries currently, which may have an agreement that only deals with goods, free trade in a particular set of products. So maybe not even all products. Maybe they carve out and don't liberalize in agriculture, for example. Don't have things about commitments on service and so forth. The U.S. is different in this. We have a gold standard of trade commitments, which is really quite extensive. So I want to give you an idea of the areas in which the U.S. has typically negotiates commitments with its free trade agreement partners. It certainly will include the standard liberalization of goods trade, manufacturing, and agriculture. There are some instances where there are particular products, for example, sugar or rice, that may not be part of a free trade agreement. But broadly speaking, the U.S. really tries to insist on eventual liberalization of all goods trade, zero tariffs. Sometimes that's phased in, but the idea is to have a really quite free flow of goods across borders. Now, the U.S. typically has relatively low tariffs on a lot of products, so that they don't necessarily have the U.S. doesn't necessarily have a lot of liberalization. It's often the other country that does more liberalization in goods. The U.S. also will insist on a broad array of new disciplines, new liberalization in the services sector. Now, this is an area of broad U.S. competitiveness in financial services, insurance services, in accounting services, a whole array of things, which is an important part of U.S. exports. For many years, the U.S. has run a deficit on the goods side, but surpluses on the services side. So it's an important part of the coalition for a U.S. Trade agreement is in the services sector. There are also requirements to go beyond the intellectual property rights commitments under the TRIPS agreement at the WTO. Now, don't have time to go into all the details of the TRIPS agreement here, but intellectual property requirements under TRIPS, that is protection for copyrights and trademarks and patents, is embedded within the WTO system, but there are many instances in which the commitments are not as deep as the U.S. would like, especially in developing countries. So the United States, in order for countries to get permanent access to the United States market, say in goods and services, we will require or expect commitments to protect intellectual property beyond what is in the WTO. So you'll sometimes hear this word TRIPS plus for U.S. FTAs. They go beyond what the commitments are in the WTO. Now this is very controversial. Don't have time to go into that now because it involves pharmaceutical patents and protection of movie rights and music rights. So this is a sensitive topic. The United States also has various investment protections embodied in a FTA. Now, what do I mean by that? That's really deals with foreign direct investment that takes place across the borders. One of the concerns for many multinational corporations is that if they invest in a foreign country, if the government of that country nationalizes or seizes those assets, it may be difficult for the multinational corporation to get its money back. And so there's this fear of a loss of investments by the actions of a foreign government. So a very important part of most U.S. FTAs is to build in investment guarantees, procedures to protect those investments into the FTA. Now this also is a very controversial aspect of FTAs. Many critics of U.S. Trade policy will say FTAs are not trade agreements, they're really investment agreements to protect U.S. multinationals. And to some extent that's true. The U.S. is already pretty open in many products, but there are these extra protections for foreign direct investment. So for example, there is a process for investor-state disputes. What that means is that there are procedures, essentially arbitration, where if a Canadian firm investing in the United States feels that a U.S. Federal government or state has somehow expropriated the value of their assets, there's a process outside of the U.S. court system to try and deal with getting a fair compensation for that. Also, U.S. firms operating in Canada get that same deal. So it's controversial in part because it's a way to get around the domestic courts. Of course, that's the whole point. There's concern that there's not sufficient protections in the domestic court system. So you have this process that is to some extent parallel and to some extent takes the place of the domestic courts. And again, this is a controversial aspect of U.S. FTAs, but it is indeed part of every U.S. FTA that has ever been negotiated. Now, a final aspect that is controversial is the potential labor environmental standards. Let's step back for a second because, in the end, what an FTA is about is once you sign this agreement, it essentially offers permanent access into the U.S. Market, which is, of course, of great interest to many countries. One of the concerns that people skeptics about globalization have is that this, combined with the investment protection, would allow U.S. multinational corporations to set up shop abroad, have protections under the investor-state dispute, take advantage of lax environmental or labor standards, and hurt U.S. workers. So there are various aspects that have been built into U.S. FTAs, and this has increased over time, that expects certain levels of standards in the foreign country in order to get access to the U.S. market. For example, there's something called the May 10th Agreement, which involves the FTAs with Korea, with Colombia and Panama, which required those countries to agree to adhere to some core International Labor Organization labor standards in order to get access into the U.S. market, and also that the countries adhere to certain multilateral environmental agreements in order to get this access into the U.S. market. So this is increasingly about changing the expectations about what policies foreign countries can pursue in order to get access into the U.S. market. Now, one final aspect of this that I'd like to note, which is these agreements, these FTAs, potentially can be ended. Typically, built into this is a 6-month window where any of the parties can say, in 6 months, we're going to exit. We're going to get out of this agreement if they feel like it's not in their interest. So it may be, why is this important? One is that if a country fundamentally feels like this agreement is not in their interest, they can decide to leave. That sovereign right remains. Another aspect that I'd like to focus on is rules of origin. Now, this is a general term in free trade agreements where for a country to get access to the benefits of an FTA, they have to show that their origin is in one of the countries involved in the agreement. For example, if U.S. and Mexico have a free trade agreement, and China brings products into Mexico and then sends them through Mexico into the United States, that's a way to get around restrictions on China. So built into these agreements are various rules of origin requirements. And this is essentially paperwork that says a certain amount of the value of a product must be made in North America, for example, under NAFTA in order to get NAFTA treatment. So this complicates the life of a business, because they have to show, if they're going to take advantage of the free trade agreement, they've got to show that they have enough value in the agreement countries in order to qualify. Now, final word to say about this: you're not required to take advantage of those agreements. So, for example, if there's a small tariff, say a 2% tariff, that is usually applied on a product, and a company sees that in order to prove that they've got the right rules of origin, it takes them 5% of the value of the product to satisfy the paperwork, they can decide to say, well, I'm just going to take the 2%. I'm not going to get, it's not worth it to me to try and take advantage of these preferences. So a company's not obligated to satisfy the rules of origin, but if it tries to take advantage of the benefits of the FTA, then they have to satisfy these bureaucratic arrangements. That's true in the United States FTAs, and it is true really in every FTA that's really ever been negotiated. So, again, basic structure is goods, services, and then, importantly, intellectual property rights, investor-state disputes, and labor and environmental standards, at least at some level, especially in more recent agreements of the United States. So this is how the structure of U.S. FTAs has traditionally been implemented up to now and likely in the future.